Welcome to K&L Gates Working Wise podcast series. My name is David Lindsay, and I'm a partner in the Raleigh office of the firm's Labor, Employment, and Workplace Safety Practice area. In this podcast, I will discuss the Supreme Court's recent decision in Encino Motor Cars versus Navarro, finding that service advisors are exempt under the Fair Labor Standards Act, or FLSA. The Court's decision in this case to reject the narrow construction of FLSA exemptions may have broad-reaching implications for employers. On April 2, 2018, the Supreme Court ruled that auto service advisors employed at car dealerships are not covered by the overtime requirements of the FLSA. The majority determined that the employees fall within an FLSA exemption that excludes any salesman, partsman, or mechanic primarily engaged in selling or servicing automobiles from overtime pay. The Supreme Court's ruling overturned a Ninth Circuit decision that the service advisors could pursue a wage and hour lawsuit against their employer because they were eligible for overtime pay. This was actually the second time the Navarro case had reached the Supreme Court. Previously, the Court had considered whether courts should give deference to a 2011 regulation from the U.S. Department of Labor, concluding that sales advisors should not be considered exempt. At the time, the regulation reversed long-standing Department of Labor guidance on this point. In a 2016 opinion written by Justice Kennedy, the Court determined that the Department of Labor had failed to provide adequate explanation for the 2011 change and held that courts should not give the regulation controlling weight. On remand, the Ninth Circuit once again determined that the service advisors should be considered non-exempt. And in the most recent decision, the Supreme Court once again reversed. Justice Clarence Thomas, in an opinion written for the majority, stated, quote, "A service advisor is obviously a salesman," end quote, and went on to conclude that the service advisors met the requirements for the exemption. The opinion rejected the Ninth Circuit's interpretation of the statute, delving into an arcane discussion of the application of something called the distributive canon of statutory interpretation. Far more importantly for employers generally, the Court changed its view on the appropriate construction of FLSA exemptions. Specifically, Justice Thomas rejected the Ninth Circuit's finding that FLSA exemptions should be narrowly construed, writing, "We reject this principle as a useful guidepost for interpreting the FLSA." Justice Thomas went on to find that the FLSA gives no textual indication that exemptions should be narrowly construed, and accordingly there's no reason to give the exemptions anything other than a fair, rather than a narrow, interpretation. Traditionally, courts interpreting the FLSA exemptions have used the narrow construction principle to construe the exemption against employers. In cases where there was no clear-cut answer as to whether an exemption should apply, courts would generally use this principle to break the tie in the direction of the employees bringing the claim. Going forward, this will likely mean that employers claiming that an FLSA exemption applies to their employees will have a lower standard of proof. The FLSA exemptions may be applied more broadly by courts than they've been applied in the past. This is particularly important because over the last few decades, employers have seen a steady rise in wage and hour class action and other types of wage and hour lawsuits. Sophisticated plaintiffs' firms have brought claims relating to the misclassification of a whole array of employees, from retail managers to insurance adjusters. Many employers have been forced to pay large settlements, often running into the millions of dollars. The Encino Motor Cars decision may help to level the playing field for employers in this type of litigation. By removing the tie goes to the employee concept, it may give employers more confidence that their exemption determinations will withstand legal challenge. Employers will be watching closely to see how the lower federal courts apply Encino Motor Cars' holding on statutory construction. In particular, courts will have to determine whether the statutory construction principles should apply to the regulations that govern white-collar exemptions, such as the professional, administrative, and executive exemptions. It is important to note that while the Supreme Court's ruling in Encino Motor Cars may signal a positive sea change for employers in the way that exemptions are construed, it does not apply to the interpretation of state wage and hour laws by state courts. In recent years, a number of states have passed wage and hour laws that are more protective of employees than the federal laws. In such states, employers must continue to comply with the stricter state laws, and Encino Motor Cars won't change that result. This leads to the possible conclusion that an employee may be exempt under federal law and non-exempt under state law. In conclusion, employers should be cautiously optimistic about the Encino Motor Cars decision. The case opens up the possibility for a shift in wage and hour jurisprudence in the employer's favor. It will be important in the coming months to watch for the fallout as lower courts come to grips with the Supreme Court's guidance. Employers will also want to watch to see how state courts and state legislatures react to the decision. We hope you enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you for joining us.